Good afternoon, everybody. Thanks for joining today. We're going to start here in about 2 minutes after we get everybody here in the Zoom webinar and give an extra 2 minutes or so for people who might be a little bit late to join us. We'll get started in about 2 minutes. Thank you. Okay, well, it looks like our attendance numbers have kind of topped out, so we'll go ahead and get started. I'd like to introduce myself. My name is Josh Fuller, and I am one of the co-chairs of the DAYL CLE Committee for 2023. We are excited to bring you this first CLE program for 2023 with the Honorable Ron Hurdle and the Honorable Tahira Merritt. Before we get started, just a few housekeeping items. If you haven't joined us before, or if it's been a while, we have a Q&A function at the bottom of your screen. Feel free to ask questions to either of the judges here today. We'll do our best to get those answered either during the presentation or toward the end once we've finished up with all the questions. Today's program is being recorded, so I'm not going to announce the CLE number for reporting purposes out loud, but Sherry Harris will put that number in the chat at some point during the presentation today, so please be on the lookout for that. And I'm excited to introduce you guys to Judge Hurdle and Judge Merritt if you haven't met them before. This is not their first time doing a CLE presentation like this, so we're very grateful that they've opted to do this once again. I know they had a recent presentation that the DBA did. I think it was on a Tuesday afternoon. I don't know a lot of associates or young lawyers who could just skip out on work to go to the Arts District Mansion in the middle of the afternoon. So we are very grateful that they were able to join us here today via Zoom. Judge Merritt is a 1981 grad of the University of Texas at Austin, and she followed that up with a graduate degree, JD at Baylor Law. And Judge Hurdle is a 1971 TCU grad. Sorry about your Horned Frogs in the national championship. Judge Hurdle and graduated from the Texas Southern Thurgood Marshall School of Law in 1994. And just to get the ball rolling, I'll let them go ahead and tell you about their practice and years of experience before they joined the bench recently here in Dallas County. So Judge Merritt, could you go ahead and tell us about your practice experience?
Yes, I've been practiced law before I took the bench for 34 years and began my career on the defense side of the bar. But throughout my career, it's been civil litigation and trial work. The last 20 years, I have primarily focused on the plaintiff side of the bar as a trial lawyer, representing victims of crime in civil litigation.
Yes, good afternoon. My route to the legal career was somewhat unusual. This is my third career, if you will. When I went to law school, I was 43 years old. So I was one of the oldest students in my class. I've been practicing law for now probably about 30 years. Most of my experience has been doing insurance defense, trial work. I've worked with most of the major insurance companies, so I did quite a bit of trial work with them. Had some private practice, doing work in probate and those kind of things. So that's the bulk of my experience.
Fantastic. Well, it's great to hear that we've got some very experienced judges joining the bench. Let's get started with what is an associate judge and what does an associate judge do? First of all, how do we have associate judges and where is the authority to create an associate judgeship come from? Judge Merritt, I'll target that question to you.
Our authority comes from the government code, and basically the function of the associate judge is to assist the district court judge in any matter that will push the case forward to a resolution, to a trial or some type of resolution. We can also hear with the consent of the parties and the consent of our district court judge, we can hear jury trials, we can hear bench trials, matters, from anything from discovery matters to temporary restraining orders, anything in a lawsuit that needs a decision on, I would say. I don't know, Judge Hurdle, if you have anything you want to add to that, but basically.
I would just say that we can be assigned any matter by the sitting district judge, up to trials if the parties agree. Judge Merritt and I are assigned to different courts here in Dallas County, and each judge does it differently. Some judges don't use associate judges' assistance at all, and that's fine. But depending on where the case is pending, that judge may have us do different things. We both don't do the same things, although we're capable of doing identically the same things, but every court is different. I will say this, that once a district judge assigns a matter to an associate judge for hearing, that party cannot object to that assignment. They can't appeal any ruling that an associate judge makes, but they can object to the associate judge hearing that matter.
Great, thank you. And you guys both kind of touched on it, that you support the civil district court judges, which we have quite a few of here in Dallas County, being a large metropolitan area. So specifically, how are you guys assigned in terms of the judges you work with?
I'm assigned to the 14th, the 68th, the 116th, the 162nd, the 191st, the 193rd, and the 298. So as Judge Hurdle said, some district court judges don't utilize associate judges. For example, Judge Moyer, the 14th, handles all his own matters. And some, for example, Judge Whitmore with the 193rd, I only handle certain matters for her. So it really depends on the court that we're in, but those are the 7 judges or district court judges that I'm assigned over.
I don't think there's any rhyme or reason to the assignment. I think it's just arbitrarily done, maybe because of past, but I work with the 95th Judge Purdy. I work with the 101st Judge Stacy Williams. I work with the 160th Aisha Redmond. I work with the 192nd, which is now Judge Frazier. And I work, 192nd, which is now Judge Maria Sila. And I work with the 44th, which is now Judge Frazier.
So let me tell everybody my judges, which I just said the numbers, and I assume for our audience's benefit. So the 14th is Judge Moyer, the 68th is Judge Hoffman, the 116th is Judge Parker, the 162nd was Judge Moore, who's now been elected to the Court of Appeals, and sitting for her until the governor appoints someone else is Judge O'Neill. The 191st is Judge Gina Slaughter. The 193rd is Judge Whitmore, and the 298th is Judge Tobolowski.
Great. So it's important to know it's not just a free agent system out there. You guys do have, courts that you support specifically, and within those courts that you mentioned, not every judge may utilize your services. So it's important to know who you
Yes.
support and whether they need you.
Judge, while you're on that point, can I make another point, please?
Please go ahead.
Even though we've been assigned to specific courts, Judge Merritt and I have agreed that if one party is out or unavailable and there's a matter to be heard by that party's court, then we will cover for one another. So just because we've been assigned to specific courts, it does not mean that you may not see us handling a matter in another court.
Great, thank you for that clarification. As an associate judge, what does your daily schedule look like? Judge Hurdle, you want to start?
Well, like I indicated earlier, every judge does it differently. The type of things I handle for the judges from the courts I support may not be the same things that Judge Merritt handles. So every day is different. Some courts I'll handle their dismissal docket. I do a lot of submission work. As a result of the pandemic, we're still hearing a lot of motions by submission. So we hear default judgments by submission. We hear motions for substitute service by submissions. I also look at different aspects of a court. I do motions to compel. We see a lot of those. So every day is different. There's no standard 8 to 5 process. It just depends on which court you're handling that particular date and what that judge is asking you to do.
I echo what Judge Hurdle said. My schedule, there are some days that I've dedicated to a particular court if that's what the court wants. So on Wednesdays, I usually handle the 162nd, which is Judge O'Neill's hearing docket. On Tuesdays, if Judge Hoffman has something for me to do, I will do that. On Thursdays, I have Judge Tobolowski's submission docket. So it really varies. There's no set time. We are always at the courthouse between 9 and 5. And we have matters that are put on our calendars, and obviously we're prepared. We review whatever materials the parties provide us to review, and review what's in the case prior to the hearing, so that we can understand what the parties want us to rule on.
Got it. Thank you. And then branching off from that, when you're at the courthouse from 9 to 5, do you have a support staff such as a clerk or court coordinator helping you guys out?
You're looking at it. Unlike the other courts, we do not have staff, and there are pros and cons to everything, I guess. We don't have staff to help us, but by the same token, we don't have staff to manage. But we pretty much do everything that comes before us. I will say this, when we talk about assigned duties, one of the things that we do probably more of are temporary restraining orders. As most of you know, this is a need for the court to enter an order probably many times on an emergency basis. And so Judge Merritt said that we're here usually from 9 to 5 every day. So someone can always find an associate judge to sign a TRO. So that's one of the other things that we will always be available to do.
And while Judge Hurdle's talking about TROs, that is the one matter that cannot be the associate judge's ruling on a TRO or cannot be appealed. So the audience needs to understand that if you file a TRO and it ends up one of us hearing it, that's not something that can be appealed de novo to the district court judge. That's an exception to the appeal process. We also don't have court reporters assigned to our courts. So if you need an evidentiary hearing, then you need to make arrangements to have a court reporter for us. We have our own individual courtrooms on the 6th floor. I'm in 6B and Judge Hurdle's in 6C, but we don't have bailiffs. We don't have court reporters available. So if that's something that you want a record, then you have to make an arrangement to bring your own court reporter.
Great. And that's, really important for young lawyers to know and understand is, who's supporting the judge, or in this case, perhaps not supporting the judge, and then just the logistics around scheduling hearings and getting hearings and making sure the right people that need to be there are there. Judge Hurdle, you mentioned a second ago that we're still kind of backed up from COVID and the pandemic. So in terms of holding hearings in person or virtually, do you have a preference? What have you found most useful? And just tell us a little bit about your courtroom in terms of virtual versus in person, if you don't mind.
Sure. I think that's a very critical point, Josh, that you mentioned the backlog from COVID. And you didn't ask this particular question, but I do want to just state that before I'll give you the answer to what you posed here, is that there sometimes is a tendency to not want an associate judge to hear a matter. Okay. And I think that's a mistake because as we mentioned, we've got a big backlog now, and it's not unusual for you to ask the district court to hear a hearing and they say, okay, I can see you in 2 months. So if you really want a case to move forward, you probably should take advantage of an associate judge. You really had to bite at the apple twice. So if you don't like the rule an associate judge provides you, you still can appeal that to the district court. But I'm assuming most of you out there have been practicing for a while. There have probably been a lot of times you didn't like the ruling from the sitting judge anyway. So I would encourage those of you who really want to move your cases forward to kind of take advantage of the associate judges. Now, as far as Zoom hearings and in-person hearings, I think we learned a lot. Zoom hearings are effective, okay? Well, you can get people in a hearing from anywhere across the country. The problem with a Zoom hearing is that if it's going to take a long time, a Zoom hearing is not very effective. You have to shuffle documents and exhibits via the Zoom camera, and it's just more effective if people can come down. Too often people will say, okay, I need a 15-minute Zoom hearing, and we get on Zoom and an hour later, we're still listening to the same case. So we're trying to figure out the best way to do that. We want to accommodate any party, obviously, and we want to do what the district court would like us to do. So just note that Zoom hearings are effective, but only if it's going to be a 10 or 15-minute hearing. It's not very effective if you got a lot of documentation, if you got a lot of things that you got to share as exhibits. So we will do either one, but just take in the consideration those issues when you schedule a Zoom hearing. Make sure you're being realistic on how long it's going to take.
I just want to add that, especially when it's a discovery dispute, and if you want the judge to go through, 75 requests for production, Zoom is not the way to go, because we expect on discovery matters for the parties to meaningfully confer, which is what the rules say, before coming to us to decide an issue. So as Judge Hurdle said, if you think you're going to be able to go through 75 requests for production that both parties are contest, against each other on via Zoom in 15 minutes, it's not going to happen. And be considerate of what the court's time as well as the other parties. For example, last week I had Zoom hearings, and I had people waiting in my courtroom for hearings. So you kind of have to realistically say, okay, is it a 15-minute hearing and I have somebody out of town, or a lawyer out of town, or a witness out of town? Well, that's very conducive to Zoom. And I think that's making the court, making our docket more efficient. But if it's going to be something that's going to be contentious, and it's going to be, obviously it's going to take more than 30 minutes, I think in person often helps the parties, because the lawyers can actually come back to the courthouse. They can meet each other sometime for the first time on a case, and they may be able to work matters out. I've had many discovery disputes. I send them to the jury room for 30 minutes, and surprisingly, they come back with agreements. So I think there's a place for both, but be realistic on setting your times. If you really have a 30-minute hearing, or do you really have a hearing that's going to take considerably more time?
That's really good insight for young lawyers who are scheduling. You may think you can get through it really quickly, but it turns out that's probably not going to be the case. Obviously, you would think they run a lot longer than getting out of there quicker. So give yourself that extra time is what Judge Merritt is very kindly telling us. Back to the assignment and relationships with the district judges y'all support. Can you talk about, just in very broad general terms, how often you meet with them, what kind of planning goes into, your docket and managing the docket? Judge Merritt, if you'd like to start.
When we first, we consult with our district court judges often, meet with them often, and I'd say that we try to look at as each one is different and each judge approaches their matters a little differently. I think it's important for us to do what we can to understand their reasoning and thinking. For example, on an emergency TRO or some discovery dispute or something that is a little different, then you sit down and at least say, what would you do in this situation, or what's your thoughts on this area of law or something like that. But I think because each of them handle things so differently, it's important for us to approach each matter very specifically, given the facts and what we're dealing with. So I think we handle it very methodically for each court.
I think we don't do this in a vacuum. Okay? When we first took these positions, we sat down with each of the judges that we support to try to get their view on how they handle certain things. And the goal was to be as transparent as possible. We don't want one ruling from an associate judge to be 180 degrees from what that sitting judge would rule. And sometimes when a matter is appealed, I got a call in from a judge and say, look, let's discuss this. This matter was appealed. And we discussed it, and I gave her my rationale for why I ruled the way I did. And she says, okay, I just wanted to know, I'm just going to affirm your ruling. So the notion that an associate judge is going to rule one way and the sitting judge is going to probably be 180 is probably not a good valid perspective. So when you take those things, of course, nobody wants to have an adverse ruling. So obviously you want to appeal that ruling that's been adverse to you, but very rarely are we 180 degrees out from what that district judge is considering.
And both of you have touched on it a little bit so far in our conversation, and I figure we should just jump in. Appealing an associate judge's ruling or order, how does that work? What's the time frame? Who gets to do it and who gets to see it? I think you've already mentioned the district court judge has, the review of that. What's that standard of review? If you guys could just talk a little bit more about that, that'd be helpful. Judge Hurdle, you want to get us started there?
Yeah, basically, you have 7 days from the date the ruling was signed or the order was signed, and that goes to the sitting judge. And obviously, like I mentioned before, in my cases, whenever there's an appeal, then the judge will call me in and we'll discuss that. It's a de novo de novo hearing, so you get to present the same information. And like I said, you get 2 bites at the apple there. A lot of times, and maybe I'm letting the cat out of the bag here, but sometimes if you've been deficient in your first motion, that gives you a chance to go back and cure that deficiency. So you may have an opportunity to get a better ruling. But that's kind of the process. And like I said, it's not done. We don't rule in vacuums. We usually have a lot of coordination and communication with the sitting judges.
Judge Merritt, do you have any additional thoughts to elaborate on?
I agree. I think that any young lawyers that are setting hearings need to understand that our rulings are really, they're advisory rulings. And you can appeal it. Obviously, you got a de novo, like a second bite of the apple, as Judge Hurdle was saying, but we are going to do what we have to do to be in line with what we think our judges would rule. So I think that the idea of, well, well, you can't object, as we said earlier, you can't object to the associate judge. So it's a situation where I don't think there should be any concern of going in front of an associate judge with a matter. It's something that we are going to be, of course, be thoughtful about and also discuss with our judges that we are working with.
Great. Getting a hearing with an associate judge. You've talked about associate judges there are there to help keep moving a case forward, to move it toward resolution or conclusion. So I file a motion. I want to get a hearing with you to get some dispute resolved. How do I physically, get something in front of you to make sure that Judge Merritt or Judge Hurdle is the one who's going to hear this? Because, like Judge Hurdle alluded to, we're a little backed up in some courts, and you could be a month, 2 months, or a little bit longer out from a hearing. So how do I make sure I'm going to get a hearing with an associate judge, if that's at all possible? Judge Merritt?
You would call the clerk's office to set your motion. And obviously, all of our authority comes from our district court judges. So if you get a date that's later than what you'd like, you can always ask that the clerk, the court coordinator, confer with the judge and ask that the matter be set on the associate judge's schedule. Of course, any authority we have has to come from our judges. So they're either going to say yes or no, or they want to hear it themselves. If we're hearing, we get it heard, then it's put on our calendar to hear. So that's how it works. So you'd call the court coordinator and the clerks and get it, tell them you'd like to have a hearing with Judge Hurdle, and then they'll get that scheduled as long as the district court, his judge, says it's okay. Judge
Hurdle, is that describe it?
That pretty much sums it up, yeah.
Okay. I thought so. Since hearings with associate judges may be a one-off event, you have a quick, discovery dispute to resolve, or, it's a TRO that, hopefully is a one-time event. How does a young lawyer effectively bring an associate judge up to speed, particularly, let's say, in a discovery context where you may have a dispute that's been going on for several months or longer? There's a lot of background, a lot of procedural history in the case. What are some effective tips and practice pointers that a young lawyer can do to help bring you up to speed so that you can make the best ruling with all information available to you? Judge Hurdle?
Well, first of all, I want everyone on this call to know that Judge Merritt and I are conscientious in looking at these matters. We will normally review the procedural history, the facts of the case. So I tell everyone who appears before me, don't waste your time reciting the facts to me. If you need to recite a fact to bolster your argument, that's okay. But too often I see people saying, well, Judge, this is a lawsuit that involves blah, blah, blah. Well, you're wasting your time. And that's critical time. I'd rather you get directly to what the argument is. If you're here on a motion to compel, Your Honor, we sent discovery request on this day, blah, 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 et cetera. Don't go back through the history. Now, I may ask you some questions, but assume, first of all, that I've read the pleadings and I've read the procedural history and I understand what the facts are. And I may have questions about the facts, and if so, I will ask you that. But try not to waste your time regurgitating what you've already put in your pleadings. Get directly to why you are here and what you want us to do.
Excellent advice. Judge Merritt, anything that you can elaborate on Judge Hurdle's position there?
The only thing I would add is if you want us to review voluminous written materials and are going to provide us with notebooks, please do so 48 hours before the hearing so that we're not reading, 5-inch notebooks or 10-inch, 2 5-inch notebooks. and we get those at 4:30 the evening before the hearing at 9 o'clock. It's helpful. I mean, both, as Judge Hurdle said, we are diligent. We read through the case, we read through whatever the materials the parties provide. But if there are additional materials or matters that, you know, are in a notebook, for example, a discovery dispute, it's helpful to have it a little bit in advance. Also, I would say that I've been provided on the hearings that I've had in person with the PowerPoint presentation, and that's been helpful in terms of a printout of the PowerPoint presentation that I can be looking at. Our courtrooms are being worked on with technology right now, and soon we'll have the ability to have video presentations. But right now, just the printout, if you're going to show a PowerPoint presentation, just a printout of it would be helpful to bring. And I think those things are helpful to get us completely, to get us the information we need. And yet, Judge Hurdle is absolutely right. You don't want to spend a lot of your time on here are the facts of the case unless we ask you a specific question about it.
Great. Really excellent advice, especially for young lawyers, but really for anybody who's in your court. We've talked about it a little bit. I'm going to ask this maybe sort of a backwards way. Are you limited in any way to the matters that can be presented or referred to you? Judge Merritt, can you get us started there?
Well, I'm not sure what you're asking, but since our authority comes from our district court judges, you know, I think we are limited to that. However, I think what you're asking is, so I've had 2 or 3 occasions where the parties on a matter that a discovery matter, for example, that I've heard earlier this year, will call, they're in the middle of a deposition and they need a ruling right then at the time of the deposition on whatever question it is. And so a lot of times they'll call the clerk or the court coordinator and say, we need a judge to make a ruling on a deposition objection, and one of us will be there to rule on it, so that the deposition could continue to go forward, that you don't have to stop the deposition and then file a motion to compel to go back. So what we're trying to do is to keep the litigation going toward the resolution, the trial of the case, or the resolution of the case. So I don't know if that's what you were asking, Josh, in terms of something.
No, that absolutely gets us there. Yeah, I was just trying to figure out, you know, we've talked about the many things associate judges do. Is there anything they perhaps don't do? Judge Hurdle, is that?
Sorry about that. Well, I would just say that we're only limited to what the judge asked us to do, which is, as you realize, a judge can give us authority to do anything up until actually trying a case with the approval of the parties. So I don't see us being limited. So if a judge asked us to hear a particular matter, if you appear before us on that matter, assuming we have the full authority to hear and make a ruling on that matter.
Got it. Understood. We've talked a little bit about practice pointers, perhaps specifically for discovery disputes, which I imagine a lot of young lawyers handle. Do you have any pointers for young lawyers about how they can effectively advocate for their side if they are trying to obtain more discovery, obtain a deposition, or on the flip side, perhaps say, you know, we've had enough discovery and we really don't need more. We don't need any more compelled discovery. Judge Merritt, can you get us started there?
Well, I think one of the frustrating things as far as discovery disputes, and I think it's frustrating for the parties, but it's also frustrating for us, is that meaningfully confer really means sit down and meaningfully confer on matters before the hearing and have a conversation. Don't just pick up the phone and say, well, I tried to call the other side and they didn't respond, so here I want you to rule on 34 interrogatories, whatever it is. Have your order, your proposed orders ready for us, and make sure we have those are filed before the hearing. So if it's filed the day before, it's not going to appear on our system until the next day. So you can bring an order with you, but it's more effective if we have it, obviously a proposed order, from both sides, one denying the relief or the other granting the relief, because you really don't want us typing, I promise you, typing orders or taking, we're relying on the parties to make sure that our rulings are accurately reflected in the order. I think one of the difficult things is also having multiple attachments. So let's say it's a discovery dispute and you're moving to compel requests for production, answers to requests for production. You can put those requests in the body of the motion rather than attach multiple copies of the same document. The document that was sent, for example, and then the answers. What I need to see is the question and the answer in order to make the rulings. So I think be mindful of, okay, is my judge going to have to flip through 100 pages before they get to the one question that you want me to rule on? So think about, I think everyone needs to think about, okay, if I get this motion, am I going to be able to, is the judge going to be able to look at it and come to what is it that you want, and what are they preventing you from having, basically? Those are on a discovery dispute, for example. Make it easy for us, give us the roadmap that you would like us to rule on, and make it easy for us.
I would think that if you talk to 10 judges, all 10 would say the worst hearing they've got is a discovery dispute. And that's not to say that there aren't valid disputes to discovery. But what I've learned and what my practice is, if you come before me and you've got 34 interrogatories and 15 RFPs, and the other side has presented boilerplate oppositions or objections, the first thing I'm going to ask you to do is to go into the jury room and see if you guys can play nice for at least half of that stuff. And what I've found, Josh, is that, when we really sit down and we are professional in our approach to what we're doing, we can resolve a lot of our issues. And I find that 35 interrogatories may be boiled down now to 5. I don't mind ruling on 5. Okay, if you guys can go through the bulk of it, and stuff that really is a valid dispute and there's some concern, but that's going to be my approach. So if whoever comes before me and they've got a long litany of stuff, just be ready to be asked to go into the jury room and try to work out as much as you can. And then those things that you can't, after a diligent effort, I'm willing to kind of sit down in front of the parties and see if we can work through. But this notion that I'm just not going to do anything for these 35, I'm going to let the court make a decision, not for me. I'm going to make you and the other parties sit down and really have a meaningful discussion about what's valid and not.
Great. So meaningfully confer. Both judges have signed off on that approach, and that's a requirement of the local rules, of course. So before you get in front of Judge Hurdle or Judge Merritt, you better make sure that you're there and has possibly narrowed the scope of the dispute as much as possible. Judge Merritt, I wanted to piggyback off of one thing you were talking about. I've seen it before. I've probably been guilty of it myself. You've got the discovery motion attached as Exhibit A, or my request attached as Exhibit B, are the respondents' responses and objections. Therefore, you're going through a bunch of different paperwork. How are you guys reviewing motions and attachments? Are you doing it digitally, electronically on a computer? Are you printing this stuff out and actually flipping through pages? And just let us, inside your chambers, if you so speak, about why.
We're trying not to kill any more trees. So normally for myself, I read it digitally on the computer. I don't print anything out because normally on the discovery motions, it's going to be hundreds of pages. So I do that. If it's something like that, the parties usually provide us notebooks, and that makes it easier as well. If you've got a notebook with your motion, the defendant's response, and those types of things all in one, and then proposed orders, that makes it a little bit, if it's voluminous and I need to take it home and read it, then I have it in a notebook. So that's just for me. I don't know what Judge Hurdle does, but that's what I do, is I read it on the computer if I can.
I think for me, it depends on how much it is, and if it's a complicated issue. If it's something, my preference is to pull it up on the computer to try to read it. Obviously, if there's several documents I have to read in conjunction with the hearing, that makes it more difficult, and I may print it out. But the idea is to, as Judge Merritt says, to use as less paper as possible. We're in an electronic digital age, and so I'm trying to accommodate that. But if it's not too complicated and I can pull it up on the screen and read it, then my preference is to do it that way.
Great. Well, we've gotten a lot of preferences and pointers and ways to understand how associate judges work today. Just to recap from what I've got written down, Judge Merritt, you want proposed orders and you want them order granting and order denied. You want the parties counsel to come prepared so that you have something to sign, and so that you're not the one filling out the order yourself or typing out the order, which I'm guessing you just won't even do. You won't even entertain it. Is that correct?
Well, I mean, in a pinch, I can handwrite it in, but it's more, here's what happens when you don't come with your or have your orders filed prior to the hearing. The court makes a ruling, and then there's a fight over the form of the order. Okay. So unless there's an agreement on the form of the order after the hearing and y'all submit an agreed order that I know that everyone agrees to the wording, and I'll sign that. So if I have, if I want to take something under advisement, for example, a motion for summary judgment, I'm hearing a motion for summary judgment. I want one granting the motion for summary judgment, one denying the motion for summary judgment, so that I can listen to the argument. I can take my time to review the materials, and then I can take it under advisement and rule shortly thereafter. I don't want to wait more than a few days to make a ruling. Or if I'm going to, usually I rule right then on the bench. But if it's something I feel like I need to review cases that you've given me at the hearing that weren't included in your motion, or supplemental matters or a supplemental brief or something like that, then that's of assistance. So I don't have to review my notes, figure out what, if what was said at the hearing. It just makes it a lot easier from my point of view. I don't know about Judge Hurdle, what his practice is.
Well, obviously, you need to prepare and provide a proposed order. We do see hearings that no one's prepared an order. We say, well, what do you want me to do? You haven't given me an opportunity to do anything. I don't have a problem if the order is not specific to what my ruling is going to be, because I can go through and electronically scratch through certain aspects of it. But you should be prepared at a hearing to say, Your Honor, this is how I would like for you to rule based on my proposed order.
Great. Very, very helpful information there. It's, specific to your practice, but I think something that would, most Dallas County judges would agree with. The other thing I wrote down was the amount of time for a hearing. Obviously, people can come to you with, small piecemeal disputes, but, we've talked about some of the larger discovery disputes, numerous requests for production, interrogatories, a lot of attachments and exhibits, to make sure you have enough time for that hearing so that you're respecting the court's time, as well as anybody else who may have a subsequent hearing later in the day. Have you ever had a problem with somebody running too short?
Too short or not too short?
What, in terms of the 15-minute, the 30-minute, 45 to an hour, what would you say is kind of the happy medium in terms of how long just as a baseline that someone should be thinking about in terms of how long a hearing should last?
I guess it depends on the matter. Let me, the first week I was here as an associate judge, there was a pro se matter, a pro se litigant or self-represented litigant that matter that I handled for Judge Hoffman. And it was hours of discovery disputes with the self-represented litigant. So I took the time in that case to make sure that party was fully heard. So we don't want to shortchange anyone on their time, but at the same time, I think if it's more than, it shouldn't run hours. It really shouldn't run hours unless it's a situation like I just described. And that was days and days of multiple hours of hearings. So that's been my experience. I don't really like to have things go on for hours and hours.
Judge Merritt and I have kind of conferred and discussed on this issue, and we just stopped short of having a timer on the bench. And I know that's offensive to some people, but when you consider that there are people waiting to be heard and you've asked for a 15-minute hearing and we're now an hour and a half, it becomes a problem. I don't think anyone is concerned if you estimated 15 or 20 minutes and it goes to 30. That's not what we're talking about. Judge Merritt can probably attest to this too. We both trial attorneys and we like to talk. And sometimes we're talking about stuff that's ancillary to what the motion is even about. So we try to keep you on track. And this is a little pet peeve, and don't take it personally. If I continue to pull you back on track because you kind of gotten off to a tangent, it's so you can effectively make your argument in the time allocated. Sometimes we want to talk about so many things, and I'll say, we're here on a motion to compel this discovery response, where someone will get off on a tangent of talking about the plaintiff or the defendant or what happened on this date or whatever. So we try to corral you back in, and that's for your benefit. So don't get offended by that. But if you say you're going to be 15, 20, 30 minutes, 10 or 15 minutes is okay. When you get beyond that, then that means you haven't effectively evaluated how much time you needed, or you kind of gotten off track.
So a matter of logistics, but also just a matter of advocacy and staying on point and making sure that you're focused on why you sought the hearing in the first place.
Exactly.
Great. And then the last thing I wrote down, the notebooks, again, young lawyers handling discovery disputes. You could have a motion and a bunch of attachments that you want the judge to consider, not all of which may be conducive to being viewed digitally or electronically. So by all means, get you guys the notebooks at least 48 hours in advance, because no one wants a notebook being dropped off at 4:30 on a Thursday afternoon before a Friday hearing at 9 a.m. Universal agreement on that one?
Yeah.
Great. I'm not seeing any Q&A in our chat box here. So now would be the time. Participants, if you have questions for the judges, they are here for our benefit, very graciously joining us here today. So now would be the time to ask them a question, obviously not specific to any case that you're handling, but something broader perhaps. And then also a reminder for those on the CLE here today that Sherry Harris has provided the CLE number so that you can go ahead and self-report your CLE. Still not getting any questions. This is a fantastic opportunity. Well, seeing none, Judge Hurdle and Judge Merritt, thank you very much for joining us here today. I think the attendees on this call are probably a lot better off in terms of being litigators, but also just being prepared to have you on the bench and potentially interact with you in a hearing setting or otherwise. So thank you very much for joining us. We appreciate you taking the time out of what we have learned are your very busy schedules. And we look forward to having you on the bench here in Dallas County for many years to come.
Thank you.
Thank you, Josh. Thank you, Sherry.
Thank you.
Thank you.